Hello, everyone, and thank you for joining us today. My name is Kit Tovar Jensen. I'm the staff attorney at the Center for Agricultural Law and Taxation, and joining with me is Guido Vanderhoeven. He is our agricultural tax specialist. And today, Guido is going to be talking about farm succession planning and some common mistakes that pop up during this process. We get a lot of questions here at the center about just where does a farm family even begin? Because it really can be a very daunting process, even though it is very important. So that's why we wanted to make this resource for you all to just as a starting point to see what's out there and learn a little bit more. So with that, Guido, thank you so much for being here today. I will let you take it over.
All right. Well, thank you, Kit, and good morning, afternoon, morning, evening, night, whatever it is, whenever you're watching these. And as Kit said, we hope, she and I, that this will be a resource that can be used as folks plan, and we have a focus on succession. This is from one generation to the next for the farm business, but also we're looking at estate planning. And I think that estate planning and succession go hand in hand. And this is a presentation that I've put together, and it looks at avoiding 10 common mistakes of estate planning and succession planning. And I think they go hand in hand. So first off, we look at a disclaimer. This presentation is intended for educational purposes. Neither Kit nor I are providing any legal or tax advice. And we strongly encourage, as families gather around the table to talk about things, but also then as decisions are made, that you go find a competent professional so that they can actually work on their own plan and get those in shape. So with that, where we're going to, this is a conversation about assisting families with the stuff, and the stuff is a very technical term. We've got a photograph here of an Iowa farm, and you can see buildings and grain bins and all those kind of things, growing crops in the field, and this is all kind of the stuff of a farm business. It can also be a ranching business, or it could be a forestry business, depending on where individuals are located. But it is moving that ownership, that equity, that wealth, if you will, from one generation to the other. And the popular press has had this that you can see in the upper right-hand slide of the slide here, that there are about $30 trillion in assets are currently held by baby boomers, and that number may be low based on where the stock market is performing today. But it makes it really kind of easy when you look at this and say, okay, 30 trillion is going to be shifted over from the baby boomer generation, which has been happening, and this happens now. This is happening as I am speaking and as you are listening over the next 30 years. Well, for me, 30 trillion, that's a pretty difficult number to wrap my head around, because a trillion is 1 followed by 12 zeros. So I did a little math, and that is, if we look at this and we just can agree that this number is valid, that means then that 2.739 billion with a B transfers each day, or $114 million transfers each hour, or $1.9 million transfers each minute. Folks will pass away, the whole process starts. Folks may be funding trusts, and that is part of the process as it transfers over to the next generation or for the benefit of the next generation. So that's just something to think about. And again, this is the presentation is envisioned to be a help. Maybe it's a motivational type of presentation to say, go out and do something. If you haven't done it already, where do you start? How do we do that? And maybe that's what we're trying to figure out. This is the first presentation in a series of presentations that Kit and I hope to put together as a video resource that you can find at the CALT website. So where are we coming from? Well, personally, I have had an extension career in excess of 30 years. I have helped rural families with farm and ranch type of management issues, One of those issues was wealth transfer. How do we do that? How do we create a succession plan? How do we create an estate plan? And sometimes that whole process, that whole task is difficult to discuss. Folks are facing their mortality. And the other issue is, how do we be fair to the on-farm heirs or the in-business heirs versus being equal to all of the kids or all of the beneficiaries as a total package? And one of the folks that I helped about 25 or so years ago wrote a very nice letter, and I actually, this second bullet came out of that letter, and they said one of the more valuable things that I helped this particular family work through was that they learned how to eat an elephant, which was this big task, and that was one bite at a time. And that's exactly what this is think through, and we will talk about some of those items, and that's what we want to do. We want to share some thoughts today and hopefully motivate the listeners and folks to have discussions between spouses, to have discussions within families, to see what would be the best, how is the best. And also what we're going to try to do is be Iowa-centric in our conversation. Now here's a quick picture to consider. In a sense, this particular visual is a synopsis of my entire 30+ year career in helping families with this. You can look at wherever you want to start on the green circle that's in the center. You can start with the wants, you can start with the needs, you can start with the haves. It doesn't matter. Let's start with the haves. Sometimes that's an easy place to look at. You can see what resources do you have, which ones are liquid, which ones are not liquid. What are the business resources that might be available? Do you have employees? Are these key employees, or are they staff that help grow your business? What about the family? Who likes the land? Who has respect for the land, or have everybody moved away? Is there any business involvement with the next generation or generations? Are there special circumstances, grandchildren, marriages, personal debt? And do you have a current estate plan? And we'll talk about these things maybe in a little bit more detail. Then you look at what is it that we need? What do I need to have? Do I need additional resources? What's my projected retirement income? Updated estate plan, if we need to do that. What are your goals? And I think these questions are very important for you, the listener, to think about. And that is, what do you want your life to be like in the future? And what do you want for your family in the future? Do you want them to be involved? Do you want them to carry on? And in the recent weeks, I've had phone calls with folks that are dealing with this, and some folks have heirs and beneficiaries, and other folks do not. And so that gets down to the third bullet here under goals, and that is, what do you want to have happen to your stuff? Those things that you have, the land, the equipment, cattle, grain, etc. What do you want that to happen? And we will talk about these things. This is a quick picture to consider. So what I want to do with this particular presentation, and let's share with you 10 thoughts in my experience looking at them, and that these, whether they are mistakes, but to try to avoid these things, to think through these things. And for those that may remember, David Letterman had a late night TV show, and he upon occasion would have the 10 top things. So I've kind of borrowed this from him, so with apologies. They aren't in any particular order, as you can see on the slide, except for number 1. They may be somewhat simplistic, but I think they are useful because sometimes it's the simple things that get overlooked, or we don't think about taking that particular bite and starting to work on that set of items that we need to go through. And it's, again, no particular order, no specific order to these except for number 1. And actually, we're going to do these in reverse order. We're going to start with number 10, and we're going to end up with number 1 towards the end.
So Guido, before you jump into your list, can you talk a little bit about what are some reasons why do people avoid estate planning, farm succession planning? It can be uncomfortable to talk about, like you said, facing your mortality and talking about finances, but Is there anything that you see?
In my experience, Kit, and that's a really good question, my experience has said that number one, it could be a little bit daunting. As we will see for many folks today, as I'm speaking and we're speaking in March of 2021, that the estate tax is probably not going to be much of an issue for many folks. It's not to say that folks won't have a taxable estate, but they won't have. And early on in my career, that was not the case. And I think the daunting thing was, well, golly gee whiz, I don't want everything to go to the government, if you will, in estate taxes. And so they decided not to do anything. The other thing was just the task itself. A lot of farmers, a lot of ranchers, they really love what they do. Growing crops, raising animals, marketing them, and there's always a list of things to do. There's not enough hours in the day, and this is one of those round to it's. Whenever I get around to it, I'll do it. And this is why I think you and I both have this passion to provide maybe a motivation, a cheerleading type of presentation. This needs to get done. But it is as important a work, in my view, as getting the genetics right in a cattle herd, getting the planter set correctly, getting the sprayer set correctly. All of those things are very important to have a successful production season. Folks have worked many years to acquire. They may have inherited. They may be the beneficiaries of parents and grandparents, or maybe even great-grandparents. And how to get this done, and the work needs to be valued. So I think that folks may value the need or know that it's important. They just may not have the timeline or the time frame in focus. When I taught undergraduate students at North Carolina State before I joined the Center for Agricultural Law and Taxation, I would try to encourage them in the conversation when we would talk as in succession and planning in the farm management course that I taught, that even when they leave the university and they begin working with mom and dad, or if there's a partnership, they need to think about what it is now, even though they're in their 20s, but it is a lifelong process to work with, and hopefully we can make an argument and bring those out. So Kit, it's an excellent question, and I hope that that was not maybe a $2 answer for a 50-cent question, if you'll allow me to use that analogy.
No, that was perfect. Thank you so much. I'm excited to hear more about your list.
Okay, so let's start with the list. So the number 10, as I said, we're going to go through 10 to 1. And again, these are not in any specific order, but sometimes the issue is, and a mistake is made, is that folks don't know where the stuff is. The actual farmer, the family, the spousal couple, the executor, the administrator, the trustee, and perhaps maybe the beneficiaries. They need to know what and where that stuff is. I think that an individual and his or her spouse, they need to sit down and create a list of the stuff. And in the farm business management type of scenario, this is the balance sheet. And looking through that and looking at what are the assets, what are the liabilities, trying to figure out what it is that we have. There are going to be the business assets, and then there's going to be the non-business assets. So it could be the car, could be some investments, IRA accounts, those kind of things. They need to be brought into the broader picture and figure out who's going to have what. And we will look at this as we develop through. There could be assets that may be in fact lost or forgotten. Could be paid up life insurance. You're not getting a bill anymore. You might get an annual statement that your life insurance value, your paid up at life insurance cash value is this amount of money. Do you remember where you got that? Did you put that in with the permanent papers that you might have? What about personal property? There could be, great grandfather's gold watch that he received when he retired from the railroad. This may in and of itself have some intrinsic value, but it may have huge sentimental value within the family. I don't know. And again, as I said, the business property, the equipment, the livestock, the land, the buildings, those kind of things. And today, March 2021, we're in a connected age. There are virtual accounts, financial, social media. A question, when I would do this presentation live, I would ask the question, how many of you have a Facebook account, as an example? And oftentimes, there probably 50% of the people in the room, and many of these folks are 60 years or older, would have that. And oftentimes it's the grandmothers that have it to maintain contact with the grandkids, understand those linkages. And so my question to them, and as I ask the virtual audience who may be listening, what do you want done with that Facebook account when you pass away? Do you want to give access to that so that it can be taken down? Do you want to leave it as a static memorial? What's going to happen? How does that work? And then also some auto pay and online payments that may be automatic, and they can't get going and continue to go unless somebody has authority to turn those off and stop those payments. So it's very important, I think, to know where the stuff is and who and what those items are. We tally them up and look at dollar values on what they may be, but there may be some that have very little value, such as the Facebook account, for example, where grandmothers and grandparents are communicating with grandkids. Very important to maintain those relationships and to continue to build those relationships. But I think it is also important to know what happens to these accounts when the owner of that account or the creator of that account or that Facebook page passes away. Number 9, as we're moving into it, is not titling the property. It could be that the titling is incorrect. It hasn't been brought up to date. Is joint tenancy with the right of survivorship. That's what the ROS stands for. Or in some states, for married couples, they have tenancy in their entirety, which is a joint tenancy with right of survivorship, but it is only for married couples. It could go that if the property hasn't been updated, the titling hasn't been updated, it could go to the wrong person, and that's a problem. What about common tenancy? Do we go to common tenants who've got 3 kids, they inherit the property from mom and dad after the second to die as an undivided third interest? Well, a minority interest could cause consternation. One of the kids may need to cash out. There may be a demand that we don't know. How is that going to be dealt with? Is there a method to settle disputes that's already there? Is there a method or a buy-sell agreement that maybe provides some guidance in that case? Because you don't want to have family land in common tenancy where somebody gets an upside down happy face and they make a petition action, and then the land goes to auction and it's bought by somebody outside of the family. I think that would be very, very much unexpected and a great disappointment to all concerned. How is it titled? Is it a fee simple with 100% of all the rights, or are there a division of rights? Is there a conservation easement on the property? Is there a utility easement on the property? Where is that easement? What's the term of that easement? Is it permanent, or is it some kind of term limited for 30 years or 40 years or whatever? Is there a life estate? Probably not as commonly being created today, but there are life estates out there that were created sometime in the past. Is it a granted life estate, or is it a retained life estate? And these are items that need to be clarified in this listing of the stuff from in page that we looked at just a moment ago. item number 10. But how is it titled today? What's going to happen to it? How does it flow? What about TOD, transfer on death, or POD titling, paid on death? Is there a reason to do such a thing? Maybe we're looking more at financial accounts. Maybe we're looking at automobiles. It may be very easy. You know, mom's got a car and it may go to Susie, her daughter. So, but not until mom has passed away. So it may be a TOD, it transfers on death. Why would we want to do that? Why would we not want to do that? And this is where you need to have your counsel, your individual counsel, that you can have this discussion with so that you can get the right plan for you. And then GIS systems, just a little note here, that's our looking at the spatial relationships and property and titles and information system. It's the geographic information systems that we have. These are very helpful to attorneys and other professionals that may be helping folks. They can go back and take a look-see, pull these systems up, look at the public information, and be able to make sure that the titling, this is the way it is currently recorded. Is this what you want? Is this really the facts? And then be able to make a change if necessary. So broadly, item number 9 is making sure that the property is titled correctly. The mistake you want to avoid is having it an incorrect title on this property. Item number 8, or mistake number 8 to avoid, and that is hanging on to the stuff. We're all getting older, and we look at what we have. Maybe it's something that we want to start moving things to the next generation as part of a succession plan. Maybe gifting is part of that plan. And again, one's own legal counsel can help look at that, and maybe a financial planner can also bring his or her feelings and thinking into the dynamic so that folks can make a very good decision. Not using gifting. In other words, give with a warm hand as opposed to a cold hand. Today, 2021, the annual gift exclusion is $15,000. The donor can give $15,000 to as many donees as he or she wants. We also have a lifetime gift exclusion amount, and for 2021, as you can see on the screen, it's $11.7 million. This is inflation adjusted. It's going to continue to be at this level under present law until, with inflation adjustments, up until December 31, 2025. There may be a change forthcoming. We'll see. We'll talk about that in just a little bit on a different slide. But we can use lifetime gifting. I don't need the farm per se. I don't need the ranch per se, or I don't need the business around the corner. Maybe I have a successor. Maybe I want to move some of that equity over. In other words, giving that warm hand, sitting back on the porch, if you will, and watching to see what the next generation would do with it. Hanging on to the stuff, but not putting it to good use. I've seen this in my career where folks just hang on to it, and the productivity of the land starts to diminish. That may not be a good thing in the long run. So thinking about that in that context. The other thing is we need to know, and we need to have a good foundational understanding of what cash or income stream is needed to maintain a standard of living that we have and that we enjoy today. Maybe it is that we can't give this stuff away. The retirement plan is Social Security and farm rental income. I understand all that. But looking at these, at least addressing it, putting it on a piece of paper, and then saying, nope, we'll check the box. I've had numerous conversations over the years about folks who raise the ethical or moral dilemma. They want to divest the wealth of the family to the, and they want to give it away in order so that long-term care needs can be picked up by the county or by the state. Well, remember, there's a 60-month look-back period, and it gets to that question: why would you want to do that if you have the means to take care of yourself, isn't that something that we probably ought to plan for down the road? Maybe it's looking at long-term care insurance. Earlier is better than later. As one ages, the chances of needing it, therefore the premiums are more expensive. And I understand that farming and ranching is a capital intensive business. We often are asset rich and we're cash poor. But I think we need to look at this, but it does raise the question, I'm going to give all my stuff away and then basically impoverish myself so that I can get the county or the state to pick up long-term care for me. I've got some questions, and that's maybe a discussion for another day. Item number 7. This is another issue that I often see as an error and one that needs to be addressed and seriously addressed, and that is not updating the beneficiaries or the ownership of various financial accounts, life insurance policies. I think almost any insurance agent, and I know that many farm management folks that I have worked with across the country have got war stories about this, and it's occurred to me as well, sitting across the table from an individual trying to explain why the death benefit of a significant life insurance policy is going to an ex-spouse. And the reason being, the beneficiary wasn't changed. So that life insurance policy was either not canceled or there was no beneficiary update. It went to an ex-spouse, and the insurance company is looking at it and they're saying, you know, the individual that took out this policy is now passed away. There's no way that we can discuss, did you really mean it to go to this individual and not another individual? It is unfortunate and it happens, but it needs to be addressed. Likewise with retirement accounts, financial investment accounts, or installment contracts. Is the installment contract, is it going to be self-canceling? If we sell the farm because we need the income stream, but we're going to sell the farm to the on-farm heir at a preferential price and maybe at a very nice and attractive interest rate. But what happens when we die and we don't need that income stream anymore? Does that installment contract go to the estate and self-cancel? Does that installment contract go to the non-farm heirs and they can continue to look at that, and the individual that has bought this property continues then to make payments to the heirs? This is part of being fair to everybody. Maybe the on-farm heir bought the land at a discount, and so not to disinherit, if you want to think about it in that way, the non-farm heirs would inherit the remainder of the installment payments as it goes through until the conclusion of that installment contract. Very important to think about. Is this what you want as you go through looking at these contracts, looking at the estate plan? Is this something that you want to have go forward? It's also part of how do we successfully transfer assets and be fair. I have seen where the on-farm heir got the line. If you look at it dollars and cents wise, they may have gotten the lion's share of the inheritance, but their return from the farm assets, the cash return from the farm assets, is much lower than maybe a stock portfolio that was inherited by another sibling. And the stock portfolio may have been less in money, but they were getting maybe an overall long run 10% return. Maybe that's fair. Maybe that's being equitable to balance out how we might want to see this going to the next generation, where the on-farm heir is not bound. The on-farm heir has the flexibility and it has the ownership position, so they can make decisions based on what they want to do in their business. The tracking of beneficiaries of these instruments is very, very important. It needs to be documented, and there needs to be a record. It needs to be, somebody needs to know about where these are. In my case, I've communicated with my wife, I've communicated with each of my 4 children, and I've said, here's where it is. I update a sheet of all the contact information, all the values that I may have in place, life insurance, retirement accounts, etc. And that's in our safe. And there, it's in an envelope, and it's marked with a marker, and said, this is important stuff. Don't throw this away. This is something that folks may want to do and think about how to communicate, as we will see. That's important to communicate this with those that may have to deal with these issues once folks pass away. In my case, if I pass away, hopefully my wife and my children, what I've done, set them aside, is going to at least take out some of the heartburn of dealing with all of this. Let's go to number 6. Number 6 is kind of similar to number 7, what we just looked at. And number 6, the mistake here, or the error to avoid here, is not keeping up with legal developments. So here the encouragement is that on occasion, every 3 or so years, check to see if there have been any changes in federal or state law that could affect or may even improve your estate plan. There could be something that either the the Congress has done or the state legislature has done. You may need to look at that. Currently, trusts are probably what are used commonly that provide the greatest amount of flexibility to accomplish planning goals. Prior to 2010, we had something called a bypass trust or a credit shelter trust, when the estate value was much lower, that could pass tax-free from the decedent to the heirs. Trusts have probably supplanted that, because at the value that you see in the middle of the screen here at 11.7, so $23.4 million between married couples could be protected in 2021. The estate tax itself as an issue is not as great as it was in the past. Matter of fact, I read some information this week that essentially only approximately 0.2% of all estates are going to be subject to an estate tax. So this is for folks that have estates greater than $11.7 million as individuals, or as married couples, 23.4 million. But these changes may affect, and we need to keep up with those legal developments. Oftentimes, legal counsel, your attorney, may send a letter out to former clients or current clients and say, the tax law has changed, the estate tax law has changed to XYZ. I would suggest let's have a meeting and review your current estate document to make sure it still is in providing you the best potential outcome and accomplishing your planning goals. The other thing that we do want to make sure is that we do want to use the portability option. This is the use of the deceased spouse's unused exclusion amount. We also refer to it as the DSU. It does have needs to be made that election on a timely return. And this is how properly addressed a spousal couple can protect the $23.4 million in assets. If my estate, for example, is only $1 million and I pass away, then I would like for my spouse to take opportunity and benefit from the remaining $10.7 million. So the portability from my estate to her estate is the use of the deceased spouse's unused exclusion amount, this DSU amount. That's how that would move over. And as you can see there, about 99.5% of US estates broadly won't pay any estate tax. Depends on what obviously the asset mix is. But for rural landowners, so farmers and ranchers, for the next while, it should be relatively safe because the 11.7 million does get currently an inflation adjustment and moves up over time. Now, we've just had an administration change. New administration was sworn in January of 2021. We do know that candidate Biden had proposed some issues relative to tax and tax changes. Some of that is going to potentially look at the federal estate tax laws. They're going to be come under review with the possibility of some legislative change. And be reminded that one Congress cannot bind another Congress. So it could ping pong back and forth. It could, as the Tax Cuts and Jobs Act did double it from the nearly 5.5 million to 11.5 million, as you see here. So that has increased. That was by legislation. The 11.7 million, as it grows through 2025, if nothing changes, on January 1, 2026, it will revert to prior law. That, based on an inflation rate of about 1.8%, should give us somewhere about a $6.4 million estate excludable amount in 2026 if federal estate tax law doesn't change between today and March of 2021 and sometime in the future. So the encouragement here is that all of us should keep a weather eye out to any of the forthcoming changes. Even this week, I have had 2 conversations with individuals who have said, well, did the tax with Biden and the recent act that was just passed, did that change the estate tax? No, that has not been addressed at this particular moment in the middle of March 2021, but it could be forthcoming. And if it is forthcoming, the center will continue to update and apprise people of those things. So not keeping up with the legal developments, the changes in tax laws, at either the federal or the state level is definitely something that an error that you do not want to mix. So we've just gone through 10 through 6. Now we're into number 5. We're about halfway through. One of the things that I've noticed as a mistake is looking at the wrong person for the estate job or asking the wrong person to do the estate job. And I think that the individual and the families need to have a serious conversation, and they need to choose the right or the correct people or persons to do the job. We most time look at the executor, or now we're also seeing the trustee. Who is that person going to be? Is that an individual who's the next generation? So is it a child? So younger than you and generation down, or is it 2 generations down? Or do we just say, you know what, I'm not going to burden my family. We have means that we might be able to do this, and we're going to use a disinterested third party who's just going to work through the documentation, and you end up using a trust department at a bank, or there are some folks that are professional fiduciaries, and they act on behalf of either a decedent or somebody who wants the trust to be managed when they no longer either can or no longer want to manage these assets. So choose the right people. Look at that executor or that trustee. Are they younger than you? I worked with an individual that chose a sister to be the executor. Unfortunately, the sister developed Alzheimer's and couldn't do it. And then you have a little session that you have to sit down through and say, well, who's going to be backup? Well, there wasn't a backup. There was not a contingent plan in place. So think about that. Are there minor children? Or is there a disabled family member that might need some additional care? Who's going to take care of that? Who's going to be the guardian for these minor children or disabled family member? One of my fellow colleagues who was a practicing attorney and did a lot of estate planning basically said that the first will that he drafted was when mom and dad went on that first vacation without the kids. And mom basically would say, I am not going to get on that airplane until we have a will in case something happens that I know that somebody's going to take care of the kids. That's sometimes an event driven, and maybe it's very simple, but what we're talking about here is how do we look at a 40-year, a 30-year, a 45-year career and the business assets. And one of those things we need to think about is, what about the minor kids? What about a disabled family member? Who's going to take care of them? Another thing that I am pretty strong about is look at separating the money job from the people job. An individual, the trustee who's looking after the money, needs to be somebody who's familiar with finance and who's familiar with some of these things, and that's a strength. That's something that they can do. The skills for the people job, who take care of the people, disabled family member or minor children, takes a different set of skills. So please think through who's going to do it. It could be it's all one and the same person. More than likely, it's not. And looking at how that money job or that people job, how they need to be separated, trying to get that correct set of skill sets to address the needs that are there. And I'll be certain that you've asked and received agreement from folks to serve in these capacities, because sometimes folks are surprised. Well, I'm going to just have so-and-so do it. Well, if you don't ask so-and-so, they might be well surprised, or they may move away and they may not be able to come and do it. There could be something that says, well, they live in this jurisdiction. It's going to be a little difficult for them to act in this capacity in another jurisdiction. Be certain that you've asked and that you've received agreement. And then, as I mentioned a little bit more, be prepared for contingencies. How deep is the bench? Is the bench deep enough so that you can got some fallback to go through? But prepare for those, because life sometimes will throw curveballs. Number 4, and this is a big one. This is one that I've run into many, many times. Farmers or individuals that may be listening, there may be somewhat of a, and I don't trust attorneys or doctors. Sometimes I'll do in kind of with tongue in cheek, I'll say the farmers typically, they would prefer to go to the vet than to go to the doctor. But sometimes professionals are, even though they are there and they can be greatly helpful, there is a certain amount of uncertainty, whether you want to call it distrust, but it's the lack of communication that we're focusing on here. Folks will play with their cards very close to their chest. There's no communication between you and the executor as you're kind of giving the executor some things to think about in going through, or the trustee, or the communication in the written documents is very vague, or maybe even with the beneficiaries. And there is, in the rural sector, there is a secretive type of attitude. Talking about wealth and money in the rural community can be seen as rude. But I really strongly think that individuals that are planning this, looking through this succession, is that you and the family need, let me repeat that, need to talk before it's too late. I kind of like to say, what you need to do is you need to talk a year before you think you're going to have to. And a family meeting, and perhaps you want to have an outside facilitator. And you might not want to have a family meeting in the kitchen, because the kitchen is really mom's place, if you want to think about it in that way. And the other thing is, there are knives there, and those are sharp, and they could do bodily harm. Not saying that it's going to happen, but that is it. You may want to have it at maybe at a, and I realize as we are recording this today in March of 2021, maybe a little bit difficult to go to someplace like a bank conference center or a conference room, or maybe an extension conference room to talk through some of these things. And sometimes an outside facilitator helps families work through if they need to do this. Just a suggestion. And a resource may be an outline of how to conduct a family meeting. And we have a resource that we're working on that will be providing hopefully for families to utilize. But please talk. So,
can I ask a question when you talk about families?
Yes.
Who do you include in that? Families can come and look a lot different now. There can be blended families, in-laws. Some people don't have traditional families with children. They maybe are looking at neighbors that they feel like are family. Who do you include? How immediate is that?
That is a most exceptional question, Kit. And I'm glad you asked it, and I'm glad we've got this slide up. This actually, and let me answer that question as I talk about this slide a little bit. So this happens to be a photograph that I took of my father about 10 years ago. Dad is still living, and he and I were taking a farm walk on his farm, and this is in the Flint Hills of Kansas. My father's, and to answer Kit's question, I think it has a lot to do with family culture. Is it a family inclusiveness? Do we include maybe the in-laws? So, and in my family, I'm not saying this is the way to do it, but in my family, my father and mother have chosen to include the in-laws in any of these discussions. Whenever they want to talk about something, my dad will write a letter, and it will be to the kids and their spouses. I have 2 sisters and I have 2 brothers. So he brings 10 individuals into the conversation with them and mom and dad. Some people may say, no, I'm just going to keep it to my kids. If there's a second marriage, it could be, no, this is going to be the way I want to do it with this property, because this property came down through my family line and I want it to stay within my family line, my children from my first marriage, as an example. So, Kid, it's a difficult question to answer, but I think it is one that needs to be addressed, and that is, what's the family culture? There's not a right or a wrong answer, but I think it needs to be a communicated answer that this is what we're going to do, and try to make a blend of that answer. A friend of mine had a second marriage. His first wife succumbed to cancer. He had 4 children. His second wife had 2 kids. When they married, they made a gift to her 2 children, and then said, anything from here on, it's going to be share and share, 1/6 each different way. That was their culture. They set it up so that it was equitable when they married, so that her 2 kids wouldn't feel like they were getting left out or they were being shunned. They wanted to do it. And likewise, his 4 kids had advantages that her 2 kids hadn't had. So they kind of tried to balance it, and they tried to be fair across the 2 families. But they were very clear in their communication, and they said, this is the way we're going to do it. This is what we think is fair. And you need to come and see what that is. Mm-hmm. Sometimes the farmer who is operating the farm has a totally different concept of what's fair than maybe the non-farming spouse. The non-farming spouse may say, well, I love my children equally, and we're going to do it share and share alike. 4 kids, 25%. 3 kids, 33 1/3%. However it goes. That may be on the surface seeming to be fair, but what about that on-farm heir that wants to continue the farming operation? That may not be an equitable or fair distribution of those assets, and there needs to be that conversation. So just as a note about communication. So one of these times, Dad and I were out and we were fixing fence, kind of like what I'm doing with my grandson right now on this very same property, since my dad is not physically able to do it this spring. And anyway, he and I were fixing, and I just asked him the question, just quite simply. I said, so Dad, what do you want done with your body when you have passed away? Do you want to be planted or do you want to be cooked? And he kind of looked at me and he said, well, I want to be cremated, and I want to have some ashes, about 50% of the ashes spread over on this farm that we're standing on, or that you see before you in the picture. And then I want the other 50% of the ashes to be spread over a farm in the Netherlands where he grew up in the 30s and 40s and into the 50s. And it's a place called Kasteel Huckfort. It's in the old farming area on the eastern part of the Netherlands. And I said, Dad, do you have this written down? And he said, no, I don't have it written down. I expect you to know that. Well, this was the first time that I had heard this. And I said, well, I'm glad to know it. And I'm able now to kind of share with you that story to say, you know, it's important to communicate. I can't read my father's mind, although I'm not so sure that he doesn't read mine. I'm not real sure about that. But the point is that if you communicate this, either verbally and then write it down as a follow-up so that your wishes would be done. That's the whole point. Talk and make your wishes known. And with the best outcome, your wishes will be acknowledged and your wishes will be followed. So Kit, I hope that answered the question, or at least gave a little bit of background. I don't think there's a black and white answer per se, but that's the best that I could come up with.
That is a great answer. I think that you gave every tax preparer and attorney's favorite answer of it depends, but it really does. Because I've talked to people who are just as close with their stepkids as they are their biological children, and it really, some in-laws or some, son-in-law, daughters-in-laws are not very involved in farm operations. Some are the most involved of the whole family. So it does seem like your answer is that whatever works for your family and for your operation.
Yep. Very good. Thank you for that. Well, what say we move on? So, whoops. Here's number 3. So the third issue, and that is not reviewing the estate plan. So way back at the beginning of this, I probably, if we were doing this live and in person, probably before I started making the presentation using the slides, I probably would have asked the audience, how many of you have an estate plan? And maybe 25% in my experience would raise their hand. And then I will ask the question, do you know where it is? And when was the last time that you looked at it? So that is the third area that could be a mistake or could be an error. And that is rules and laws change. They can change at the federal level. They can also change at the state level. But it should be, or it's advisable to at least review your estate plan about once every 3 years or so to ensure that it is continuing to meet your goals that you set originally. Estate planning and succession planning is, in my view, not a one and done deal. Things change, it's fluid. And maybe getting back to Kit's earlier question at the very beginning, what is something that keeps people from doing it? And that is they realize that it's difficult. It's that elephant that needs to be eaten. But what they want is they want to get it done. They want this one and done. They want this perfect plan. Let me emphasize and highlight. You cannot create a perfect plan. It's next to impossible. You can't make it perfect. But what you need to make is a flexible plan. Build in kind of some if-then statements, if you will, looking at it and say, if this happens, then this is the way it's going to go, and be clear in that communication. We need to review our estate plans, particularly after any major federal or state law change or a presidential election. We've already talked a few minutes ago about that. And so we need to keep our weather eye out. But more importantly, we need to see what's happening within the family. Circumstances change, and we need to look at those for some of those issues. Are we updating our beneficiaries in our life insurance policies and our retirement policies, those things? What happens about a divorce? What about if there's a major illness or a disability that all of a sudden changes maybe the financial picture, but greatly changes the business picture? What about births? What about deaths? Close colleague of mine, he's at the university. He's actually at Oklahoma State University. Unfortunately, about 5 or 6 years ago, his brother, who was taking over the farm, died in a tragic on-farm accident. There's two brothers, the one who's having a successful academic career, and now the brother who was the individual who is going to take over the operation is no longer. That was a huge change. What happens? And they're still working through, even 5, 6 years later, they are still working through, what does this change mean? What does it mean for me as an academic? What does it mean for my mom and dad who thought that they had the things that things happen? There's births, there's deaths, and kind of like, do we want to change? Do we want to move from one fish bowl to the next fish bowl? And do we want to go jump and do that? And there are stories and there are circumstances that listeners of this presentation may be well aware of. So yeah, I remember when so-and-so came back to the farm and, well, it just didn't work out. They didn't really like a small community, or they had grown used to, or the spouse was from a more urban area and the rural conflict, or there was not opportunity for their careers to advance one way or the other. These are things that kind of need to come into play, and review those estate plans and see what happens. So that gets us to number 2. We're kind of winding down here, but folks may fail to have advanced directives that they look at as part of their estate plan, as part of the succession package. A living will, which is to allow for a natural death. Could be, that a natural death is defined under state statute and said, okay, this is how it's going to happen. Here's the pro forma. This is what's going to happen. And ensure that there is agreement with all of those concerned. Who is the individual that will make the decision or not make the decision? Is it one of the kids? Is it a spouse? Who's the contingent in case the spouse is incapacitated but still living? All of these things. What are these items that we have these advanced directives, and what's your feeling? How do you perceive? We're living older, we're living to older ages. We've got medical technology that can do wondrous things, but what does it take? Is there an individual that has a durable power of attorney for medical needs, that if an individual becomes incapacitated, still living, but goes through and can make those decisions? Do we have life support? Do we do this particular medical procedure because we think it's going to do better? Is there a durable power of attorney for financial assets and for financial needs? Again, 2 different skill sets perhaps could be in the same person, but a financial mind may be a little bit not as empathetic if I can use that phrase as somebody with medical and trying to suss it out. More communication, clearer communication as these directives are put into place. And the key is that in my experience, the durable power of attorney, once it's signed and initiated, is in place, but it's kind of an if-then statement. If this event happens, traffic accident, heart attack, stroke, whatever, and it's determined that an individual is incapacitated and cannot make decisions for themselves, then this individual who holds the durable power of attorney steps in and carries on and can make those decisions and has agreed to make those decisions. Likewise with the durable power of attorney for financial needs. And then when an individual passes away, the durable power of attorney ceases. And then we go to the estate documents, whether it be a will, whether it be a trust document, or whatever. So these are things that we can put into place to help make the transition, make the succession be part of the succession / estate plan, or if you want to say the estate plan / the succession plan. I like succession / estate because it gives me a sense that folks are engaged in the succession planning, and that may happen prior to death as they age and become less physically able to or maybe less willing or wanting to be involved in the business and then move forward, but yet be in an advisory capacity. What about this? What about that? So on and so forth. So that gets us, as we're slowly wrapping up this conversation or this discussion, that the number one mistake in estate planning, or the number one mistake in transition or succession planning is, and this is a big oops, in my view, that mistake or that oversight is not having an estate succession or transition plan of your own design and your own choice. It's not necessarily the most difficult thing to do broadly. And yes, we've talked about there's this elephant and we've got to work through this whole thing. But the really difficult issues that I have seen in my observations is who is going to get the stuff? When are they going to get the stuff? Do they get it at death? Do they get it as a gift? And then how do they get the stuff? We've become a little bit more sophisticated in how we organize our businesses. We have LLCs, we've got sub-S corporations, we've got partnerships, we've got different kind of entities. And are we going to be granting an equity position in these entities, whether it be a partnership interest or a ownership interest in an LLC, or stock interests, shares of stock in a corporation? How does this happen? Who's going to get the stuff? When are they going to get the stuff? And how do they get the stuff? Now, some people may argue, well, we also want to figure out what they're going to do, they being the beneficiary, they being the kids. What are they going to do the stuff once they get it? And from my perspective, if they get it after death, I really don't care. I'm not going to have any word to say about it, but it is an issue. And do you want to give with a warm hand? Do you want to give with a cold hand? Or do you want to rule from the grave and really cause consternation? And there are various things, again, no right or wrong way, but I think folks need to think through this. And remember that if you don't have a plan of your own, you do have, within each of our states, we've got the rules of intestate succession. So essentially, remember that question I asked when folks, do you have an estate plan? And 25% or so would raise their hands. The reality is the other 75% also had an estate plan. That plan was the rules of intestate succession. And it may not be what you want, but the legislatures of our states have kind of figured out, well, this is the best way we can do this because we want to get these assets moved out. And you will read in the folks of so-and-so has passed away. There's no will. He didn't have a will. She didn't have a will. The court will appoint an administrator. The administrator then has to go through sorting of all of the stuff, and then it has to be signed off on by the court, and then it gets distributed out. But each state does have a way to deal with this stuff and to get it to whomever. And it may be that that is not what you want. If that works, great, use it. But in my experience with farming and ranching families, they want to create their own succession plan. They want to create their own transition, and they want to create their own estate plan as part of a working document, a living, breathing document, or sets of documents that helps make this move through. The other thing partly is not keeping up with the changes of the family circumstances. And we saw that in error or mistake number 3 up above. And that is not keeping up with those, the births, the deaths, and so on and so forth. So a couple of things, 3 final thoughts. And this is one that I made a presentation one time, and I heard this, and this was that the issue regarding estate planning or succession or transition planning is that nothing wrong has been done. It's that nothing has been done, and that's wrong. My feeling is that if you have assets, if you have stuff, then you have an obligation and a responsibility to make some decisions about who's going to get the stuff, when are they going to get that stuff, and how are they going to get that stuff. And I think broadly all of this comes down to this next bullet here, and that is in regards to using attorneys and legal counsel. Please understand that help me is much cheaper than fix me. If you got to get fixed, if there's got to be something that's got to be fixed, that means something horribly went wrong. And yes, you want to get competent legal advice. You want to get somebody who is well versed in agricultural production and has an understanding of the nuances of agricultural businesses. You want to look at somebody that may be saying, okay, this may be the best way to handle this land asset that we have. Maybe we want to put it in some kind of entity or not. Maybe the best answer is to end up with or try to get as large a liability insurance policy as one can afford, and then keep one's mouth shut so that you feel good that you've got liability coverage and that if something happens, it would be covered under the under that liability insurance policy. But I think looking at professionals, looking at trying to get some help, whether it be from financial advisors or attorneys or whatever, help me is much cheaper than fix me. And I've seen that time and time again over the years. And as we're wrapping up, sometimes these land transfers, as I mentioned just a moment ago, this is the biggest issue in farm and ranch estates. Using gifts, maybe using landowning entities such as an LLC, maybe that is the best option to use. But look at it, seek counsel, try to get that answered for yourself in your context. The use of a will or a trust, that might be the best one. However, at the end of the day, the landowner, the farmer, the rancher, the spouse, have to come together. There has to come to a decision about who gets what, when they get it, and how do they get it. And remember that a non-decision is a decision. You've just thrown your hands up and say, que sera, sera, whatever will be, and just go through it. And I don't think that that's what folks really want. They need to move through, they need to think about it. It's not a one and done deal, but it is important and it can be somewhat time consuming, but once done, I think it can bring a lot of peace of mind to folks. There are some actionable first steps, kind of as a review. Complete that inventory. Look at that balance sheet. And here's just an example. Develop some of those goals. What is it that you want? Discuss with the family. Put together that team of trusted advisors that we've kind of talked about throughout this whole presentation, whether it be the attorney, the accountant, the financial planner, the insurance agent. It might be the banker. You might want to include the banker in there. There could be some debt. What happens to that? And then once you develop and bring your plan, then you want to implement that plan. It's kind of like the old adage, you know, you want to plan your work, and then you want to work that plan and work it all out. So looking back at this slide, as we're coming to a conclusion, in summary, I don't think this says it can be said any better. In my view, you know, start where you have. What do you have? What do you need? What do you want? You want to start with goals first and answer those questions. And these are just 3 questions. There could be the other questions that you might come up with other questions that are more specific and more important to you and your situation. What are the resources that you have? What is it that you're going to need? What's the retirement income? What happens with business disposition? Is there a successor that's been identified, or successors? Or is there going to be a sale of the business? Or are there things that the business may be moved to somebody outside of the family? All of those kind of things. So that brings us to the end. Thank you for your attention. And there's a picture of the stuff there on the left-hand side that's inside a storage unit. It's amazing how many of those storage units we've got across the country as you drive around.
Mm-hmm.
You can see last will and testament, get it done. It may be that you want to use a trust. It could be a revocable trust, like a living trust. It could be an irrevocable trust. You may use a testamentary trust. All of these things, they can be helpful and brought to you.
Mm-hmm. Awesome. Well, thank you so much, Guido, for that fantastic overview of things people should be aware of, common pitfalls in this farm succession and estate planning process. We're going to be linking some of the references or resources that Guido had mentioned. We want to have you guys have access to Ag Decision Maker. It's through Iowa State Extension, and there's a lot of great resources there about how to develop goals, how to talk with your family. We're going to give you a resource called the Estate Planning Questionnaire. How do you even start to begin to develop your inventory? How do you list all that stuff that Guido talked about today? So with that, I hope you guys found this resource helpful. We're hoping to do more like this on different topics in farm succession planning. But with that, is there anything else, Guido, that you wanted to say before we end?
The only thing I'd like to say is, and just kind of highlight and repeat, hope that this has been helpful. I hope that this has maybe gotten some folks to thinking about some of these issues. And as they move forward, I would just encourage them not to wait until they have a round to it, but I would encourage them to move forward and develop that plan. And again, remember, it won't be a perfect plan, but to strive to make it a flexible plan, and that help me is much cheaper than fix me. And with that, I will say thank you and enjoy the rest of whether it's the day or the evening or the night.
Perfect. Well, thank you so much again, Guido, for this fantastic presentation. And please, anyone, if you have questions, feel free to reach out to us, and we'll do our best to point you in the right direction. So thanks again, everyone. Bye.